Hello friends, in the series on income tax cases, today we will discuss a very interesting case on section 54. In the present case, a very interesting issue was before the Bangalore ITAT B bench, and the issue was that if the assessee wants to claim the exemption under section 54 for his 17 residential properties sold, and if the assessee invests in 5 properties, so whether in that case the exemption under section 54 will be allowed only for one residential property sold, or whether it can be allowed for all 17 properties sold, or in other words, whether section 54 exemption is to be given or the exemption is to be calculated each asset wise or in totality or cumulatively. This issue has been decided by Honorable Bangalore ITAT B bench in the case of Kumar Agarwal versus Deputy Commissioner of Income Tax, and this case is reported in 188 taxman.com 93, and the date of the judgment is 29th June 2026. The facts of the case are very interesting. In the present case, the assessee has sold 17 residential properties and have invested in 5 residential properties and have claimed the exemption for the 5 residential properties against the 17 residential properties sold. The case of the assessee was picked for determining the section 54 exemption claim of the assessee, that whether they are in accordance with law or not. And when the assessment was going on, the assessing officer was of the very considered view that section 54 proviso first says that the assessee can be allowed the exemption under section 54 for the maximum of 2 residential properties purchased, and that proviso is applicable only when the property when the capital gain do not exceed 2 crore rupees, and second proviso says that this benefit can be given to the assessee only once in lifetime. So the assessing officer, by relying on this provision, restricted the exemption of the assessee for the purchase of only one property and denied for the exemption for rest of the properties sold. The CIT appeal also upheld the order of the assessing officer when the matter was before the tribunal. The assessee argued that neither the first proviso or nor the second proviso provides for clubbing of all long-term capital gains. The assessee also relied on the Central Board of Direct Taxes letter number 207/24/76, which is dated 25th March 1977, and which says that the exemption under section 54 is to be allowed asset wise and not in totality. The assessee also relied upon the Bombay ITAT judgment, and the name of the judgment is Montgomery Market Fund, and which is a 2006 judgment. The assessee also said that in the assessee's own case for the assessment year 18-19 and 19-20, the exemption under section 54 has been allowed for the multiple houses sold by the assessee, and even the return filing of the assessee when there is we go into the utility, that also allows the assessee to calculate the capital gain exemption as asset wise. When the tribunal heard the matter, the tribunal said that the plain reading of section 54 does not restrict the assessee to claim the exemption only for one residential property. The provision of section 54 only says that the exemption is restricted only for the purchase of new property to one and not for the properties which have been transferred. So in totality, the section 54 exemption will be given asset wise and not in totality. So the tribunal decided in favor of the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Pawan Kumar Agarwal versus Deputy Commissioner of Income Tax, and this case is reported in 188 taxman.com 93, and the matter has been decided by Bangalore ITAT B bench, and the matter has been decided on 29th June 2026. Thank you, friends.